Come on, Ian.
He's speaking at the APs.
I'm sorry.
Good morning, everyone. Sorry. Good morning. The ABA's in town, so sucking up all the air. As a reminder, the meeting being webcast. The recording will be archived eventually. David, do we have a quorum?
Overall, Chief Justice Nathan Heck. Presiding Judge Sharon Keller.
I'm here.
Justice Bill Boyce.
Here.
Mr. Kevin Bryant. Ms. Sonia Clayton.
Here.
Senator Brandon Creighton. Mr. John Gimbel. Judge Bill Gravel.
Here.
Representative Jeff Leach.
I'm here.
Judge Emily Miskell.
Here.
Judge Kelly Moore.
Here by telephone.
Judge Valencia Nash.
Present.
Judge Kathleen Person.
I'm here.
Ms. Rachel Rass. Chief Justice Sherry Raddick.
Here.
Mr. Ken Sachs.
Present.
Justice Maggie Sawyer.
Here.
Representative Reggie Smith. Here. Judge Ed Spillane.
Here. Judge
Vivian Torres.
Present by phone.
Mr. Evan Young.
Here.
Senator Gina Safarini.
Present.
You've had an opportunity to see the minutes of the last meeting in November. Are there any comments or objections to the minutes? There's a motion, second.
Second.
All in favor of adopting the minutes, aye. Aye. Opposed?
Aye.
Thank you. We'll go to the report of the Indigent Defense Commission. Jeff?
Thank you, Chief. Good morning, everyone. TIDC's humming along. We've got payments going out right now to 254 counties. We're in the process of processing ID plans, indigent defense plans from all 254 counties. We're working with about 20 counties that are interested in building public defender offices, so we're doing planning studies for all those. In our upcoming board meetings, we have one on March 12th, and we'll have strategic planning on June 18th and 19th. The last thing I'd like to mention, we have Representative Andy Murr, who will be rolling off of our board, and we're going to miss him greatly. We are very fortunate, though, to have Representative Smith joining us, so we're excited to have you on board, and that's it. I'm happy to take any questions you may have.
Question for Jeff. Thanks for Jeff.
Thank you.
Then we have the highlights of the annual statistical report that just came out for fiscal year 2019. Angela.
Good morning, everybody. Overall, statewide, case filings were down slightly, and particularly in courts with large misdemeanor dockets. District court cases really didn't change in terms of overall caseload, but the county courts, especially the constitutional county courts, declined, justice courts declined, and of course the Court of Criminal Appeals, since all of the criminal cases are declining. But when we dive down into case type, we are seeing a huge surge in civil cases. Statewide, there were 1.6 million civil cases filed. 40% of those are in the municipal courts, and that includes civil parking, tow hearings, dog hearings, health and safety code violations, nuisance abatement cases. And our next largest category, at 1/4 of caseload, is debt. That used to be 20% last year, now it's 25%. And our third category is basically evictions. So we're seeing a lot of cases for debt and evictions. New civil case filings have increased at every trial court level except the municipal courts. They are up 18% in justice courts, 12 in district, and 14 in county. In municipal courts, they've declined by 3%. In the district and county courts, the number of cases increased in nearly every single category. In terms of the volume of cases, the largest increases in the district and county courts occurred in debt cases. Debt cases account for 30% of those courts' caseload. Debt cases increased 37% from the previous year and 88% from 5 years ago. Huge boom. In terms of the next largest share of caseload, about 15%, are our motor vehicle accident injury or damage cases. They increased 9% last year, or in 2018, and 15% over the last 5 years. And although the number of cases was relatively small, the eminent domain cases nearly tripled, and it's because of the pipelines that people are protesting, and it may be part of the border wall eminent domain issue as well. In the justice and municipal courts, debt cases increased 36% last year and 162% over the last 5 years. Landlord-tenant cases, which are those eviction cases, have also been increasing steadily. The new cases in municipal courts declined partially because of the ban of red light cameras in the last session. The debt cases have increased to historic levels in the justice and district courts and comprise almost half of county court at law caseload and justice court caseload at this point. The surge is due to easing of regulations by the Consumer Financial Bureau. During the Obama administration and during the fiscal crisis, the Obama administration restricted debt collection activities. Now those regulations are being loosened up, and the large debt collectors are out there and they're buying more and more debt and going after and filing cases in the courts now. The Federal Reserve has also been reporting record levels of debt in terms of student loan debt, auto debt, and credit card debt. And delinquency rates are starting to rise, particularly among the 18 to 29-year-olds, according to a report yesterday. So our motor vehicle accident cases have increased significantly, primarily in the district courts, where 70% of them are heard. And over the last 5 years, 70% increase. They account for 1/5 of district court caseload and 10% in the county courts of law. After reaching the lowest levels of filing of other tort cases since 1980, those cases are starting to tick up as well, with medical malpractice driving a little bit of that. On the family side, we have been seeing increases for years. In 2019, more than 364,000 cases were filed in the family courts. 40% involved child support, which is the green, either initial child support case or post-judgment enforcement or modification of a judgment. And then the other third account for divorce, most of which do not involve children. So after years of increases, the number of new family law cases declined in 2019, down 3% for new cases and 7% for post-judgment modifications and enforcements. Filings decreased in 3/4 of the case types in 2019, including, you can see, divorce, child protection, The greatest increases over the last 5 years have occurred in protective order cases, child support, and child protection. Child support cases declined last year, though, due to the Attorney General's Office's policy of focusing on only filing cases in which they're really actionable. So if they cannot find the parties, both parties beforehand, they will not file the case, where in the past they were. So the caseloads are declining for that reason. And after 6 years of growth in child protection cases, those cases went down last year as well. It's a nationwide trend that the National Center for State Courts has seen. And at our last court statistics meeting, they asked why that was, and the speculation was that it was the Families First Act, which provides federal resources, funding for the states to use to work on mental health issues, substance abuse treatment, and in-based home parent skill building to prevent the kid from going to the foster care system in the first place. So we anticipate that filings will go down. And the number of reported pro se litigants at the time of filing, which is the only thing we capture at the time of filing, and the only at the petitioner level, has leveled off at 40%. And that is in line with a study by the National Center for State Courts that looked at family cases. Exact same figure, basically, 40% at the time of filing.
Excuse me, do you have a parental termination slide?
That's child protection. Child protection and then termination of parental rights is down 9%.
Down?
Down. In 2019, let's just say new juvenile cases, other than our catch-all category, which unfortunately a lot of people dump their stuff into, they don't classify it appropriately. Other than that big category, the next highest level is assaultive offenses. So that's going to be assault, aggravated assault, and attempted murder. So very serious cases. Roughly half of the cases were classified as misdemeanors, and 10% were not reported as in a classification to us. Since the peak in 2007, the number of juvenile cases has fallen 50% to the lowest level since 1993, with just over 27,000 new cases filed. That's because of all the diversionary methods trying to keep these kids out of court. While filings declined in most categories, significant increases occurred in robbery, auto theft, and felony drug cases. The number of fine-only criminal cases involving juveniles or minors declined 64% since 2012. Nearly half of filings in 2019 were traffic-related. In 2019, filings declined in 2/3 of the case categories that we track. Tobacco, e-cigarette, and truancy cases increased for the 3rd year in a row, and parent contributing to non-attendance of school has started to increase. But compared to 5 years ago, the only increase is in the tobacco and e-cigarette cases, where we're seeing very significant increases. More than 392,000 misdemeanor cases were filed in the district and county courts, and 225,000 felonies in 2019. Almost 40% of these new cases involve drugs or alcohol, which are highlighted in green or blue. The number of new misdemeanor cases has fallen 1/3 from a high in 2007 to the lowest filing rate since 1991. The number of new felony cases has been reaching an all-time high each year since 2014. On the felony side, filings have increased in the majority of case categories over the last 5 years. You'll see family violence assault really sticks out. And drug possession, 29%.
Just to be clear, Angela, which types of drug possession would fall under the felony case cop?
That would be opioids, wouldn't it?
Well, opioids, cocaine, methamphetamine, the penalty group 1 are the ones that would fit under the felony drug possession. It's going to be important because the next slide or so is going to maybe point out a little different on the misdemeanor drug possession. I just wanted to point out the distinction of what we're talking about here.
So
The
on
hard
the-
drugs, I guess, would be the common term.
So on the misdemeanor drug possession side, we've got marijuana possession. Right here, down 14% last year. And then the other drug offenses are down 16% too, and I think a lot of those are marijuana cases that are not being reported in the correct category. So we have a significant decline in the misdemeanor side. And really across all misdemeanor case categories, the only categories that are up over the last 5 years are DWI, family violence assault, again, on the misdemeanor side, and traffic cases. So felony drug possessions reached a new peak, while misdemeanor cases dropped sharply. And that's due to the drop in the prosecution of marijuana. I checked this morning, and fiscal year filings, September through December, have dropped 55% from 2019 so far this year. And convictions are down 42%. So along with the cases filed, there are much fewer convictions going through the system. Family violence rates have been increasing, with felony offenses growing at a faster rate. New family violence cases increased 81% on the felony side since 2014 and 9% on the misdemeanor side from 2017. In the Justice and Municipal Courts, new FIA-only cases continue to decline, although more than 6.4 million cases were filed in 2019, and almost all of those are traffic cases, with 80%. This continued historic decline in these cases. They declined for an 11th year in a row in traffic and parking cases. So the number filed in 2019 was more than 40% lower than the peak in 2006, and was the lowest number since at least 1980. We can't go, our records only go back to 1980, so we can't go further than that. Non-traffic misdemeanors increased very, very slightly, but it was still half of the peak of filings in 2008 and was the lowest number since 1984. Even though there were slight increases in non-penal code cases and local traffic ordinance cases, they're still historically low compared to 5 years ago. So that refers to all our court costs, fines, and fees, and all the items funded by those. So at the appellate level, the number of civil cases was the highest in history. And after 8 years of decline, criminal cases leveled out in 2019. With the declines in all the criminal cases, the filings in the courts of criminal appeals have been declining as well. Applications for writs of habeas corpus declined by 10% to the lowest level since 2001. And petitions for discretionary review decreased to the lowest level since 1989. And finally, cases filed in the Supreme Court. Petitions for review, which make up the main part of the caseload, increased to the highest number filed since 2002. And the number of regular causes added to the docket, that's where they accept it for review and consideration, declined by 31%, while the other petitions and writs that they consider remain steady. Good. Any questions?
Questions? Do we know why misdemeanors continue to fall so much, Angela?
They're saying that law enforcement may be dealing with other things, more serious. Nobody really knows.
Yeah, I think a couple of things, Chief, that I think as far as indicators would be the primary driver of misdemeanor criminal prosecutions are drug-related, which would be primarily marijuana at the misdemeanor level. And of course, we've seen the significant decline in the number of prosecutions of those, including a pretty significant steep decline since June of last year when a law was changed regarding the legalization of hemp, in which case there's been a pretty steady trend across the state with regard to prosecution of those. So that's one thing. The other thing I think that may be playing a factor, you see the felony cases going up pretty steadily, misdemeanors going down, which is sort of a weird thing. But I think Angela is correct in that it appears to be that law enforcement is focusing their attention on the higher level criminal activity in the state, as well as things such as the theft thresholds by inflation. You know, they're set in law by an amount, and over time, because of inflation, they go from what used to be a misdemeanor, that same stealing the same object would now be a felony because of its inflationary value. So I think we're seeing some of that escalation as well, but it's certainly pretty staggering, the difference between the felonies and the misdemeanors.
Any other questions? Thanks, Angela. That's always an interesting report. An update on court security, Mr. Gomez.
Good morning. About 2 years ago, I stood before this body and kind of had a charge in my hand and kind of a direction to go and establish and formulate a plan to get judicial security in Texas going. And the legislature obviously saw fit to institute SB 42, pass it, and institute these foundational reforms. So, having traversed the state of Texas over the last couple of years, I've seen many courthouses presented for many bodies into training entities, court security committees, to try to change the culture of court security right now. Because we're still, at the local level, at the small rural county local level, we're still challenged with the funding authorities, the individual county commissioners' courts, dealing with their issues, what's important to them. And so we're trying to change that culture in these counties to kind of elevate the importance of court security, judicial and courthouse security in some of these historic courthouses in Texas. As you know, Senate Bill 42 instituted reforms for privacy protections that we have policies and procedures in place with the Texas Ethics Commission, county appraisal districts, county registrars, and DPS. The integrity of those systems are sound. We have not had any breaches of personal security of the judiciary between those training entities and, or rather, those entities and OCA. So that's good news. Of the 4,300 judges that we've informed statewide, we have approximately 1,750, more or less, on a given day, members of the judiciary who have voluntarily complied with these privacy protections. So it's a good number. We wish it could be better, but we're also dealing with those, again, cultures in some of these small counties where judges profess, well, everybody knows where I live. They know who I am. If they want to get me, they can, that kind of thing. We're going to change this. It's a mindset. It's going to take time. It may take a generation, but it's coming. We're getting there. We're getting at a good place. And of course, as I've mentioned, the local judiciary, or rather the commissioners' courts, they haggle with that during the budgetary process, that tangible versus intangible. You know, it's kind of hard to prove a negative. How will having all these security devices and enhancements actually prevent concerns and issues at a local courthouse? But our outreach has been very focused on advising, again, all members of the judiciary, retired, unelected, resigned. We've had processes in place, for example, with the Employees Retirement System of Texas to inform members of the judiciary upon retirement of these privacy protections. We've informed both chambers of the State House, State Senate, rather, who were former judicial members of these privacy protections, the national office holders, the federal bench, former members of the Court of Appeals, Criminal Court of Appeals, and Supreme Court. Child support and child protection judges, new onboarding, we're catching them at the new hire orientation. So the outreach is going to be constant because we're going to have to deal with elections, every election cycle, and new appointments. But nevertheless, again, it'll be recurring. This is going to be a recurring messaging effort on our part. We would also like to welcome Nick Barsetti. Nick Barsetti is our new court security specialist to assist me in this grand effort of conducting courthouse assessments and presentations and training evolutions that we put on. So he comes to us from the California judicial system. He's well-versed, well-trained in all matters relating to court security. So he is from California, born and raised there, so I've been spending, he came on board about the end of December, so I've been spending a great deal of January texifying him a little bit because we need to get that out of him and get into that mindset, because he's having a crash course of it and a little challenging. So he's a good hand, and you'll probably see or hear from him in the future. We've conducted approximately 70 plus courthouse assessments, or have courthouse assessments scheduled. Historic courthouses, new courthouses, annexes, new construction. So we're providing these sound advice and recommendations, and we hope in about a year, because we're at the cusp of pushing out a statewide assessment, a survey to determine how many counties have court security committees established in their county. I think that is a very needed piece of information, and of course, where there's a void, we'll fill that void trying to get these counties on board. So hopefully the next time I'm before you, I certainly will be in a position to report 254 counties in compliance. And then again, from that point, we'll go off into the municipal court system and start surveying the municipal court system and see where we're at. iWatchTexas.com has been a very useful platform for myself. It's a DPS managed and run program. It's a reporting platform that I use to report suspicious activity, terroristic behavior, kind of pre-incident indicators. It's an iOS, it's an Apple, it's a web-based system. I've encouraged also the Judiciary to use this system. It's a suspicious activity reporting vehicle that anyone in the community can report suspicious activity. Again, the benefit of me reporting on behalf of the judge of a suspicious incident is that the data is mined for several years. It's acted upon, it's vetted by criminal investigators at the DPS Fusion Center. And DPS, I can report, DPS has been very responsive to my reports that I've sent in on behalf of the Judiciary. Some have been very serious, cartel-related threats, and some as recent as this week certainly get at what we're doing here at OCA and trying to meet these challenges of judicial and courthouse security that we're now facing. Threats are starting to increase, and informing not only Judiciary but law enforcement seems to be the critical cog that I need to place a little bit more emphasis on. But again, it's going to be, again, some counties such as Harris that come to mind, Collin, they have a very robust, dedicated court security division within the courthouse that also assesses and analyzes intelligence that's generated from the community. So again, very good models out there that a lot of counties that I'm directing a lot of counties to look at and see if they can implement those reforms again in their county. The incident reporting steady increase over the last couple of FYs. Again, that's more of a testament to local law enforcement or the law enforcement element in a given courthouse being aware of the mandatory reporting requirement. So we'll continue to see a trend again every FY until and hopefully get again every incident reported as necessary. Later this fall we are in a drafting mode with the National Center for State Courts and FEMA to present and host a COOP, Continuity of Operations training program this fall here in Austin. Bring some of the local representatives from emergency management or the Judiciary to take advantage of setting up their own COOP plan in individual counties. That is a very much needed, I think, resource here that the Judiciary needs to kind of pay attention to here in Texas, especially some of them rural counties. Later this year, closing out, later this year, I've also, in the fall I hope, if not sooner, in the draft stages of presenting the first annual report to the legislature on court security activities pursuant to SB 489. So that is something that I look forward to getting in the hands of the legislature, and hopefully look at my request, kind of look at the history of what I've been doing and see if we can at least get hopefully a little bit more funding, a little bit more help in the area of judicial and courthouse security. That is all I have. Any questions? Why call it?
Yes, Senator.
To what extent have you had a problem in dealing with a sheriff versus an administrative judge in terms of who's in charge, who calls the meetings, who makes sure there's a committee, et cetera?
I wish there was a template, because every county I go to, I have to assess and evaluate the local politics. Sometimes you have a strong sheriff and a strong county judge, and they're headbutt. Sometimes I might have the local administrative judge, district judge, might be the one calling the shots. Every county is different. There's no consistency. So I have to assess the politics before I go into a county so that I know who I'm talking to and take it from there. So it would be hard to quantify that just because of that, the uniqueness of each county.
Well, how do you assess that?
I pick up the phone and do a lot of talking. I may have some historical because of my prior history with the U.S. Marshals in the Western District and the Southern District. I have kind of a somewhat of a working knowledge of how the sheriff, of most sheriffs. I know most sheriffs in Texas, so I know exactly, gauging from their feedback, who I need to be talking to. So I do get a lot of that once in a while, where the sheriff will tell me, hey, you probably need to talk to this judge or this commissioner or this district judge. Because there's some district judges, not all, some district judges are responsible for multiple counties, so a given county may not have any local judicial representation. So it's incumbent usually upon the county judge or the sheriff to take charge of that court security committee.
I see. As you proceed with your assessment, I would suggest that you perhaps work with a few volunteers, because you can't do this yourself, but more or less mystery shop selected courthouses throughout the state to see what exactly is going on, because you will find a gap between what people may tell you versus what is being practiced. For example, they may tell you there's a great security system and you need a code to get in, but all employees and former employees have the code. So how can that be a security feature? So if you have a mystery shopper, so to speak, you can more or less
That
find
wouldn't
out
hurt at
what
all.
the
I would agree with that. Nick Barsetti, our new court security specialist, might be the one that I can just kind of ghost him into some of these places. Mystery shop. It's a good idea.
Thank you. Thank you.
Yeah. Yes, Judge?
You may have mentioned, but roughly about what percent of the counties have this security committee have set up? Or just roughly, or just from your own?
I would say half.
So about half.
I would say about half.
So it's still a significant number need to even have a committee.
It is. I mean, and the biggest issue is the fact that, well, it's not an issue, but the law's been in place 2 years. I mean, it's not for lack of awareness on the county's part.
Right.
I mean, I'm still getting calls as recent as yesterday from a judge. You know, I need to set a committee up. Can you tell me how to do it? And it's just a county or two over. So, I mean, it's really no excuse 2 years later why we're still kind of at this point.
Right.
So we'll have a hard answer. We'll have a hard answer for you, I hope, in the coming months on the status of court security committees.
And maybe the teaching entities can help too.
Absolutely.
You know, that they remember and they forget.
And we have specifically on our website, we think they know about this as well, we have webinars that exactly address court security committees and how to stand them up.
Judge Gravel?
I would just say from the county perspective as a county judge that the Courthouse Security Committee in Williamson County has just been in place about 1.5 years, and it is the most, it's the highest level attended meeting by elected officials of any committee I serve on at the county level. And in particular, in our county, we're in the process of a remodel and redesign in our courthouse system, and it's somewhere between $4 and $5 million. And most of it involves what has been the outcome of the Courthouse Security Committee. And so perhaps we're more motivated because we saw much footage of Judge Kusurik. But on the county perspective, in the counties in my area, it involves the most high-level group of elected officials. And I've just found a great level. We're putting in scanning systems of bodies, people that are coming through. It's almost $1 million. So,
Senator?
Who is in charge?
you know, that's a great question.
I'm writing my bill already.
So what has happened is that the district judges and the county court at law judges have said that the county judge is the owner and the manager of the property and the building. The sheriff is the manager of security. And so if it's a question about access, it's really a decision by myself and the sheriff for who has access to those facilities. But as far as the committee, it's chaired by our presiding district judge, and she has led well and led strong. And there have been some pretty significant redesigns come out of recommendations from the committee after we've had assessments. So really who's in charge, that's a good question, because it's really, I would say, a team would be the right answer.
And I would suggest that we look at that as we develop our legislative recommendations, so that perhaps we do need a template, as Mr. Gomez suggested, and look at that through legislation.
So the statute currently says the mandatory statutory members are the local administrative district judge, someone from each type of court in the county, so justice of the peace, county court, and the local administrative district judges heads up the committee. Oh, there has to be a commissioner on there. So the current statute does say who the mandatory members are, and then also additional discretionary members to help the committee.
But then the sheriff is in charge of security, and so that's where the clash can come in.
Well, and so the way the statute is written right now, the court security committee has the ability to make recommendations to the commissioner's court, but they would have no independent power. So it's an advisory role, I guess.
So we need to clarify the structure going forward.
The security committee, absent anyone from the court, is commissioner's court, would be a complete waste of time. And so we have to make sure that, because someone has to fund it ultimately, and so I think, clarifying that and setting a model out of that would be important.
I think that would be very helpful.
Absolutely. I mean, what's also come up in discussions around the state is lack of just funding in general. They feel that the court costs associated with funding the court security is also an issue with them, maybe insufficient. As human resources tend to take the vast majority of the local courthouse security funding.
Others? Yeah, David.
Just want to, it's easy to get lost in the statistics and the committees and all of that. I just want to report to you all the amazing work that Hector's doing around the state. Hector keeps me very informed, especially when we have an active threat against a judge. And I can tell you from our discussions that I believe that judges' lives have been saved. And this council was the initiator of a lot of the efforts, and Senator Zaffarini was the moving force in the Senate to get this across the finish line, Representative John Smithy as well. But I know there have been many times where a judge will suspect something, or even law enforcement will get a tip. And when Hector gets those calls or gets that information, he immediately goes into action, contacts local law enforcement, contacts the DPS, contacts the Texas Rangers. And I know of several incidents, which I won't bother you with today, but where law enforcement interceded with an individual and found an active threat in place. So this is not just about numbers and committees and trends. It really is having an impact. And that was really this council's goal, is to make sure that not another person, whether it be a judge or a person who's in a courthouse, would be injured. Certainly we can never prevent all of it, but everything we can do. And I can tell you that it's my belief, I think Hector would probably agree, that the work that you all started is paying dividends. So we'll keep working, but we're seeing benefits already.
Good.
I think, Chief, some of the problems stem from the fact that some people believe it's security for the judges only and don't understand that it's courthouse
Right.
security
Yep.
for everyone who's in the building,
Yep.
not only the judges. And that's where a lot of the issues rise.
Yep, there was somebody jumped over the clerk's counter in Harris County a year or two ago and was wrestling around with some of the employees back there, so that's exactly right. Great. Well, let's move to consideration of approval of designation of the court as a judicial center of excellence. We have three, Judge Maderi, Judge Klein, and Judge Villarreal. And now we have maybe a new one.
Good morning. Today before you we have the Honorable Claudia Laird and County Court at Law number 2. She is our fourth nominee. She's been working with us from the beginning. She was pivotal in helping us understand how this process can slot in and fit with civil courts. Her jurisdiction is primary civil and holds a lot of sway over guardianship and probate matters. She came into us regularly with pretty high scores across the board in most of the performance areas, strong in governance, strong in court operations. What she really lacked was just sort of codifying these processes and procedures, putting them down on paper and making sure that her staff was engaged in those processes. When I went out to see her, I found her court to be very well structured, very well organized, and her staff to be dedicated and attentive and also very open and kind, but also very flexible. When I went out there, she had reworked her docket to make sure I could see a good cross-section of the typical courts that the typical cases that she sees throughout the week. So I got to look at pro se, I got to look at guardianship cases, I got to hear an oral argument. So I was really granted a pretty good access to her court processes and how she runs through things. Every court that we've seen through this process has one thing about it that stands it out, and I hope to see more of that as we work through it. And for Judge Laird's court, it's her court visitor program. She's not a statutory probate court, but she sustains and maintains, with significant amount of court resources, a court visitor program. And what struck me about this program is that it is incredibly well organized and incredibly well staffed. Anyone who's ever worked in a program that requires a strong volunteer base knows that maintaining those volunteers can be a challenge. People drop out, people start out very gung-ho, and then, through life or challenges or even just sort of falling out of love with the idea of volunteerism, those volunteers sort of wane. To sustain this project, Judge Laird and her guardianship coordinators and her staff have developed not only resources within her county and with the community at large, but has reached out to other institutions, including universities and local community colleges, to make sure that the court visitor program is adequately staffed and that that the cases under her provision are always and are protected and well maintained. And so she is absolutely a dedicated public servant. Her staff is capable and equally committed to the cause of judicial excellence, and I therefore put her forth for nomination.
Congratulations, Judge Laird. Introduce your staff.
Okay, so over to the other side is our probate auditor, Ron Bowman. And this is Colleen Reich, she's our probate investigator. And Amy Stevens is our guardianship coordinator. And Donna, Walters is our coordinator, our court coordinator. We handle civil and probate cases, so there's more than just the probate staff. Kathy Ansley is our probate coordinator. Martha Kumar is our court reporter. And Sandy Ledbetter is the court administrator. That's everybody.
Oh, great.
You want to introduce your other two guests who are excited they're here.
And this is my mom and my son.
Yes.
If I may, when we worked on the guardianship issue, Judge Laird was absolutely outstanding. And if I recall correctly, her court had the best record in terms of compliance with state law. And I was very keenly aware of that because my county had the two worst county courts of law in terms of appliance, 90% and 88% non-compliant. And you were outstanding, even at that time before we started this process. So I'm very impressed in looking at the report about this court. Just the beginning performance area strength index is impressive. She was already at 100% in court operations before this process began, at 80% in governance, 63% in case flow management, and I believe it's 79% in access and fairness, and that is incredible. And so now you're at 100% in everything. Bravo, we need more courts like this.
Yeah.
And I move that we designate this court a court of excellence.
Second?
Second.
Well, it is great credit to the judiciary that we have courts like this, and the recognition that they've gotten in Corpus and in Laredo, Laredo, has really been good for the judiciary as a whole. And we know it takes a team. I was a trial judge 105 years ago. But I know how important the staffing is, and so we thank you very much for this. We're going to take some pictures after a while, after we finish the meeting. Any other discussion on the motion? All in favor? Aye. Opposed?
Aye.
Yes, indeed. Yes.
Chief, could you take a picture with them in this setting with the certificate? That'd be nice for us.
We're going to be on.
Are y'all heading out, or are you going to be around for a minute?
We will be, wherever you need us.
Okay, we'll just take a picture later.
Okay, I just thought in this setting it would be nice for them to get it. Just one.
Sorry?
I just thought it would be nice for them to receive it from you in this setting before
Oh,
you
in
have
this
your vote.
setting.
Yes,
Well,
in this setting.
yeah. All right, great.
Just one, you
Yep.
can take the others.
Yep.
We actually got it.
Yeah, we're ready.
Everybody get there? Ready? One, two. Yeah, please.
Wonderful smiles. Great.
Okay, 3, 2, 1.
All right.
Before I step out with them, does anyone have any questions? Yes.
How many courts in the pipeline?
We got three. We have Judge Swearingen's court this morning, Judge Miskell, and I have been in contact, and we have Judge Hale. And then we have more, Judge Hale, yes,
From
that
where?
Laredo. He just got with me this morning. He got his court review in yesterday, so we will be working with those courts really soon, and we'll see where they are. Judge Miskell's already done a significant amount of work in the process, so we'll probably have her up not too long from now.
Chief,
Senator.
I had discussed with Mr. Slayton that we should really work with the respective counties when a court is designated, so that we can make sure that these courts get the attention, the recognition that they should. For example, in Corpus and Nueces County, what they did is they installed a building plaque. And it was very, very impressive, and so we are now doing that in Laredo, and you will be invited to the ceremony, as well as David Slayton and others. But I think that we should take it upon ourselves, as Judicial Council, to inform the county commissioners' courts so that they can do something like install a plaque, and so that the local judge doesn't have to be asking for that kind of recognition.
Senator Zeffirini's suggestion, we have, with this recognition, we will be sending a letter to the Montgomery County Commissioners Court, making sure they're aware that this designation has now occurred, and giving them insight as to how other counties have recognized judges with similar distinctions, and offering that if they would like the Chief Justice to attend, that they should reach out and get on his very light schedule, his very busy, crazy, hectic schedule. But so we'll be doing that so that they're aware. Because the worst thing is, some of the judges don't feel like they want to go down to the Commissioner's Court and try to generate the respect. We should help them and make sure the county commissioners know.
I think too, Mr. Slayton, if you would include in that a sample proclamation, every county judge that I know is would be proud to do that and recognize, but it's always helpful when the
Sure,
supply
absolutely.
And we have the Webb County one that we can use as a template.
We'll absolutely do that.
Good idea.
Great. Well, Senator, I know you pushed this idea a long time, and it's really,
I think it's a wonderful project, I really do.
thank you. So we'll move to committee reports, and this will be our work leading up to putting together our legislative package for the next session. So we'll start with civil justice. Chief Justice Reddick.
Okay, the Civil Justice Committee hasn't met since the last council meeting, but it's planning a meeting in the upcoming months. Last Civil Justice meeting, the committee discussed establishing a business court pilots in a couple of jurisdictions. And I just learned, Mr. Slayton told us this morning, or yesterday, that good news is the National Center for State Courts has just granted us the opportunity to support that work, also the State Justice Institute. The grant will also provide support for training up to 25 teams of county courts at law judges and staff on expedited action rules. The civil justice law jurisdiction of the county courts at law raises to $250,000 on September 1st, 2020, and all those cases will be expedited action cases. So that's my report. If you have any questions about the county court at law, Mr. Slayton will help.
You might say a word about how that came about, David.
So, as was mentioned by Chief Justice Raddick, the Civil Justice Committee has been working in this effort to try to set up pilot business courts, and we're looking at working with a couple of local jurisdictions to do that. And the committee had discussed that at its meeting, and as we were looking for technical assistance to assist us in that work and some funding to assist in that effort, the National Center for State Courts indicated they had some funding left over from a State Justice Institute grant that they might be able to put towards it. So of course we were allotted to grab some of that money. So they will, not only will it just be money, it will actually be true technical assistance from the National Center for State Courts, who's been working around the country to set these business courts up. So we'll be able to rely upon their expertise. The hope is that by the end of the year we'll have the beginning operations of some of these pilots, and we can provide some feedback to the legislature about how they're working, maybe some challenges that we've faced. Many of you are aware that there have been bills to set up business courts in the last couple of sessions. There's been quite a bit of resistance to it because of some of the objections of both internal to from the judiciary and externally from the judiciary or from others. And so the thought is to maybe work through some of those issues and provide a model for how it might be able to work or not, that information back to the legislature. At the same time, when we were talking to them about the funding, the other issue that came up was, from a civil justice perspective, is how can we make sure these expedited actions cases are proceeding. For those of you that might be unfamiliar with that, right now there are rules that are in place that say if a case has less than $100,000, civil case has less than $100,000 in controversy, and it is meant to be expedited. The goal is to try to reduce the cost of litigation and to assist those cases in making their way through the courts. And the evaluation of those rules have been that they have not been as effective as they was originally thought, primarily because neither the judges nor the lawyers or anyone are really using the rules as they were meant to be used. So one of the things that we think will be helpful there is to provide training to the county court law judges and staff. And we're focusing there because there was a bill that was actually authored by Representative Leach that changes the civil jurisdiction of county court at law judges to $250,000 from its current $200,000 now. And all cases in the county courts at law under $250,000 or less will be expedited actions cases. So all of their cases will be. So we want to make sure they're well trained so that the rules actually have an impact, and that we are able to hopefully reduce the cost of litigation in those cases where there's not as much in controversy as the other cases. So that's our attempt, and we're going to be working with the Texas Center for the Judiciary to do that training, and we expect to do it in the early fall as close to September 1st as possible, but we're trying to get on the calendar, so that's the intent of what we're doing.
So there are a number of these operating around the country, and quite successfully. As far as the judges are concerned, the lawyers, the constituents, the legislative bodies, and so we just need to see if we can't replicate some of that here. Find judges who want to do those cases, train them to do them, so that's what we'll pursue it. Great, thank you, Judge Reddick. Criminal Justice Committee, Judge Kelly Moore.
Okay, thank you, Chief. The Criminal Justice Committee met on February 12th to continue work on our charges. And if you'll notice on the agenda, there's a sub-item that would consider adoption of this rule that we discussed at our last meeting. I'm going to kind of go through our very general report, and then I'm going to try to impose on David or Megan to talk about the judicial admonishment rule, since I'm not there in person to answer questions, and it might be easier for everybody. Related to our charge to evaluate jury and grand jury processes, we had a very spirited conversation between Shannon Edmonds of the Texas District and County Attorneys Association and Grant Shiner of TCDLA, giving us both sides, of the issue. They spoke about the perspective of prosecutors and defense attorneys, and primarily about proposals that were in Senate Bill 1492 by Whitmire last session, which ended up not passing the full body. The committee is going to continue studying the matter, and we're going to try to concentrate on the common ground areas, probably further consultations with TDCAA and TCDLA and other interested parties to try to, there were some legitimate concerns last session, particularly relating to a judge's authority to deny bail. And so we're going to try to look at some of those things that were objectionable last session and see if we can come up with some common sense recommendations for the Judicial Council that will remedy some of those concerns. Next, we had Brandon Bellows of OCA present us with an update about comments received about the proposed rule for judicial admonishments concerning firearms. We had discussed this rule at our last committee meeting, and then we addressed it at our Judicial Council meeting, I believe, in November. This is an effort to advance the governor's initiative to make sure that court participants are aware when a court order is entered that limits their ability to possess firearms, or that would cause that to be criminal activity to possess a firearm. For example, after the issuance of protective orders and any number of different type of court orders that limit one's ability to possess firearms. We made a couple of changes as a result of our committee meeting the other day, and I'm going to, as I said, when I get through, I'd like to impose on David or Megan to present that issue to the full council. Finally, we revisited our discussion of bail reform in Texas, and as you all know, this is will be our third session to work on that issue. We've had since the last meeting at least one more standing order, this one from Travis County, that basically requires PR bonds or personal bonds in all misdemeanors except for cases involving family violence, DWI second, and offenses committed while you're out on bail for another offense, and some of those. And this is just another circumstance that shows how important our recommendations and maybe legislative action could be in the area of bail, because we have counties still trying to follow the law, trying to unclog their jails, but doing it in just various fashions that I think a lot of counties are still crying out for guidance on that. And so we'll continue our work on that. And once again, we looking for ways that we can improve the objections that were made during the last session. So anyway, that's the committee report, and if it's okay with you, Chief, I'll ask David or Megan to take up the next issue.
Thanks, Judge. David?
Thank you, Chief. Thank you, Judge Moore. You have on your desk before you, those of you in person, a copy of the draft rule. This is the edited version that the Criminal Justice Committee has recommended for your. And so, to remind everyone exactly how we got here, especially since we have at least one new member. And after the shooting attacks in Midland, Odessa, and El Paso, Governor Abbott issued his firearm safety plan. And one of the recommendations of the firearm safety plan was that the legislature should pass a law requiring judges to admonish defendants or other individuals who, by the entry of an order by a judge, become already, by existing state law, ineligible to possess a firearm or ammunition. As Judge Moore pointed out, that's things like, for instance, the entry of a final protective order makes someone ineligible, or the conviction of a felony makes someone ineligible until 5 years after they complete their sentence, and other types of guardianship, for instance, placed under guardianship. Those types, they're already in state law, but there's no current requirement that judges notify defendants or individuals who are in those situations of that. And so rather than waiting for the legislature, the Judicial Council took this up and said that is something that the council has the authority to do by rule and could do quicker and maybe more appropriately, the Judicial Council doing it. And so at your last meeting in November, you approved a draft rule. That rule, as is typical with the council's rules, was published in the Texas Register on December the 13th for public comment. In addition to the publication in the Texas Register, because the fact that we felt at OCA that probably not every judge is reading the Texas Register every week, that we would send it to every judge in the state. So we asked the training and education centers to distribute it to all the judges, and they did, asking them to provide any feedback they had. We received 6 responses. I believe all of them were from judges. We did not receive any actual public comment. We received 6 responses from judges. The majority of them were not really substantive. I don't think any of them actually were substantive comments on the rule. There were a few that had questions about what does this mean, what is the consequence of someone not following their direction, those type of things. There was one, for sure, comment in support of the rule, and there was one who sort of questioned the utility of whether or not this would actually help anything, and perhaps that all of these, the laws and others, might be struck down as unconstitutional. That was really the only comment that was sort of negative in its tone. So just a reminder, what this rule does is basically it says that when a judge enters an order or a judgment that makes that person eligible to possess a firearm or ammunition, the trial court must inform that person of the person's ineligibility to possess that firearm or ammunition. If the individual is in person before the judge at the time they become ineligible, the intent is that they be orally admonished in a manner they can understand, and also be provided with written admonishments at the same time. If the published rule that you published in the Register last time said that if the person is not in person before the judge when that order or judgment is entered, that they had to be provided written admonishment, and it's not on here because we changed it. It said that that written admonishment must be served upon the defendant. Part of the concern that came out of the committee, and actually in one of the comments, was concern about the term served, because in the legal context, obviously that has a very particular meaning, and there's cost associated with that, and perhaps a judge might not even have the address of the defendant to know where to serve it. So that has been modified. Judge Nash, did you have something?
I just had a comment. I do a lot of the revocations on these from DPS, and you wouldn't believe how many defendants are unaware that they could not continue to keep their firearms. So I think it's a great idea because more of them than not have no idea once they sign off on those plea deals and et cetera. They never know that they could not continue to possess the firearm. So this does give them that information that's necessary. So I think it's a great idea.
there was some discussion at the Criminal Justice Committee meeting, and also after the last council meeting, I know there was some requests from the council for us to seek information from the governor's office, and we did check with them. The intent is what Judge Nash just pointed out, that the governor's intention, as well as I think the council's intention, was to make sure that there's actually real notice provided to a defendant that the law now prohibits them from possessing the firearm or ammunition. But also then, of course, the response to that to hopefully protect public safety, that people who aren't supposed to have firearms, hopefully at least know they're not supposed to have it, and perhaps they'll follow through with that. One thing I want to draw your attention to is under B2, so subdivision 2 here. There is a change here. It is not substantive. Well, I guess it is substantive, but it's not meant to change the intent. The committee recommended removing all the provisions about served. And so the language now just says that the person will be, if they're not in person before the judge, they'll be provided with written admonishment informing that person of their ineligibility to possess a firearm or ammunition by a method most likely to provide notice to the person. So it provides a little bit of flexibility to the judge to try to figure out the best way to get it to them without going into exactly how that's to be done. There was a late-breaking suggestion by a member of our staff, Brandon, over here, that we should move the phrase "by a method most likely to provide notice to the person" to after "the court must provide." So we read, "The court must provide the person, comma, by a method most likely to provide notice to the person, comma, with a written admonishment informing them," just to maybe be clearer in that. So we're going to, if it's okay with the council, our intent would be to move that to the appropriate place in the sentence grammatically. And just to be clear, if you were to adopt this today, we would publish it, the final version, in the Texas Register. And then it would be our intention to, as the rule provides, that OCA would bring back to you for your consideration at your June meeting a model oral admonishment and a model written admonishment that would be available for judges to use and incorporate as well. And that at your next meeting, you would consider approving that, and we would then publish it. The last piece you see is that OCA is required by the rule to coordinate with the Court of Criminal Appeals and the judicial training entities in getting judges trained on these requirements. The committee actually discussed this issue, and it was the recommendation of the committee to delay the effective date of this until September 1st of 2020 to allow adequate time for us to provide training to the judges to make sure they're aware of it. Obviously, any judge can start doing it earlier, but as far as the effective date of the rule, it would go into effect September 1st of 2020. And the last thing I would point out to you is that there was a question at the last council meeting about the impact of what happens if a judge doesn't do this, and how does that impact both the case that's before the judge as well as any future prosecutions. I don't have a really good answer for you, except to say that it appears from our research that this would be a matter of issue of first impression in the court system. The case law that's out there dealing with admonishments and required admonishments deal with pre-plea admonishments. And this, of course, is a post-action admonishment.
That's what I was going to ask David. Was this going to be before the order is entered, or, because I didn't really kind of understand the timing.
Yeah, it's
so it's after
to be, I mean, I guess they could do it before or after, but it's
it would be nice if it was before.
This is when a person by entry of an order or judgment becomes ineligible, the court must inform them. So the intent is that it be sort of contemporaneous with the order or judgment. So just to sort of, so that there is a case on pre-plea admonishments that's pretty clear and somewhat on point. And the bottom line is that it does not appear, it's not a constitutional or due process violation if they're not notified of these type of situations. There is some question about, there has to be a harm analysis to determine whether or not there was harm done. So that would obviously be a case-by-case situation. There is no case law on post-plea admonishments, despite the fact that there is already in law a post-judgment required admonishment in domestic violence case, misdemeanor domestic violence cases, that they can no longer possess a firearm or ammunition. So there's already a law that does this only for misdemeanor domestic violence cases. That law has been on the books since 2007 and has never been a part of an appellate case. So it's never been raised. So the bottom line is I can't tell you for sure that this would have no impact on cases. It appears to be an issue of first impression. However, based upon the other cases dealing with pre-plea admonishments, it's our opinion that it most likely would be viewed by court to not have harm in any particular situation. Though, sort of internally we discussed, well, what's the worst case scenario? The worst case scenario would be that an individual has an order of judgment entered and the judge fails to admonish them, and then an appellate court might reverse the case and send it back to do that case for that. So we sort of start square one with that case. The second issue might be that if in a future prosecution for unlawful possession of a firearm, presumably a court could find that they weren't provided adequate notice, in which case that prosecution might not be able to proceed. Of course, from a practical standpoint, on that day, they're now aware they're not allowed to possess a firearm or ammunition, and so presumably that accomplishes the same end. But we don't believe that to be an issue, but I just wanted you to be aware of it since it was raised at the last meeting. I know Mr. Sachs had a question.
No, just for clarification, I know that language that we're using in 1A seems a little ambiguous or in a manner the person can understand. And is there a reason why we're not requiring the written admonishment when they appear in court?
It is required in court. So if they're in court, it's oral and in writing.
Oh, okay.
So it's B1A is orally, and B1B is writing, and it's the and.
And then is it also required in Spanish and English, or?
I don't know that we're specifically saying that, except it has to be in a method which they can understand. Traditionally, court documents provided to an individual in court are in English only, but I don't think we specifically address it in the rule as far as oral proceedings in a courtroom. If someone has limited English proficiency, there's already a requirement that there be an interpreter, so they would be provided that as well. But it most likely, at least currently, most of our written documents are in English only.
And we're providing a model for the oral admonishment?
Yes, and it's my guess is that we will likely provide a model in Spanish as well.
So and if the person did sign language, you would have the interpreter.
That's correct. Too. That's correct. So that's sort of in the language that in a method that they can understand.
Thanks, Ed.
Yes, Evan.
As a practical matter, when someone becomes ineligible, what are the means by which they come into compliance? Do they transfer possession? Do they give it to the police?
Currently, that is not defined by statute. I know both the Senate and the House actually have select committees. I know Senator Zeffirine serves on the Senate. She's, I believe, the vice chair. Vice chair of the Mass Violence Prevention Committee that's looking at this, which is the law's not clear. It's actually, there's even some conflicts in the law right now with regard to this as to what are they supposed to do once they become ineligible. So I'll just give you an example where even federal and state law. So in federal law, once you become ineligible, you can't purchase a firearm. But in state law, you can still insert it after 5 years, for instance, after a felony conviction, you can possess one. You can't buy one, but you can possess one. So you can't buy one through a licensed firearm dealer, but you can still possess one. So there's both the House and Senate are looking at these issues, but there's nothing in statute that says when you become eligible, you must transfer it to a federal firearms dealer, or you have to give it to a friend or family member or whatever. And there's no compliance check to see. So they're looking at those issues. I don't know whether there'll be any recommendations come out of the committees on that, but that's really.
Is there a time period? I mean, the moment this is signed, I get the sense, that person is ineligible, not even will by virtue of this order become ineligible, but that makes it sound like, well, unfortunately for you, Judge Nash saying a lot of people don't even know that this is a requirement. Well, that's unfortunate for you because now you're not in compliance because you possess.
Yeah, so the law does, the existing laws, once again, the council's not changing the law, I'll be clear about that with regard to when someone becomes ineligible. We're just informing them of that fact. The laws that are on the books right now don't say you got to transfer it within 30 days. It says as soon as that order is entered, you are now ineligible to possess the firearm.
Maybe something worth thinking about ironing some of those, and it probably doesn't require any consideration for purposes today, but it seems like it might be useful if clarity on those points can be generated for that to be part of the admonishment. Here are the options you have. You can give it to the police for destruction. You can transfer it to someone who's not within your control, or whatever the options are.
I know both committees have had this on their agenda, so we'll see what they come up with regard to the statute, and whatever they do, certainly the council, I think, would want to incorporate that into the model language.
And the Justice Boyce, I was going to say, the governor's aware of our these efforts.
They are, yes, his office is aware, and we've been in communication with them.
Justice Boyce.
So David, looking at the language in subsection 2, providing person with a written admonishment informing that person of the person's ineligibility to possess a firearm or ammunition by a method most likely to provide notice to the person. If I understood your earlier comments, there was consideration around the idea of providing some flexibility in terms of how that gets done.
Correct.
So my question or observation is inclusion of the word most in there may cut against that consideration, in the sense that it potentially invites disputes over more could have been done. If you did it this way, more could have been done to do it that way.
So personal service would probably be the most likely.
If the goal is to not necessarily require the most elaborate personal service or the most elaborate format, then most may reintroduce that through the back door.
Correct.
And so that may warrant reference to a likely,
a method likely
to provide notice to get some more flexibility. Reasonably likely.
I think what you're suggesting is in line with what the committee was hoping, which is to give maximum flexibility to judges, so that there's an attempt to get the notice, perhaps send it to the last known address that you have, or whatever method you could use that is likely to get it to them. So I don't think there was an intention to reintroduce the conflict that we were trying to move away from with regard to service.
So likely or reasonably likely may be language that would accomplish that.
Reasonably likely?
Yeah.
So if I could, unless there's any question, I could read to you how this would be worded, just so under subdivision 2, since we've changed it just a little bit. So we would say, so under B2, we would say, if the person is not appearing before the court when the person is or becomes ineligible, the court must provide the person, comma, by a method reasonably likely to provide notice to the person, comma, with a written admonishment informing that person of the person's ineligibility to possess a firearm or ammunition, period.
Did you count the number of times you used person?
We're trying to be clear who we're talking about.
Other comments? Yes.
I just have a request. Under E, they're coordinating with the Court of Criminal Appeals, but this also does have impacts in family law, so I would just request training, because frequently in family law, the parties will agree to some of our form injunctions that we have in the family code that have the effect of making them ineligible, and they don't know when they agree to it that they're becoming ineligible. And I, as a judge, when I sign that temporary order, certainly wouldn't know if that's in there or not. So I would not have the ability to admonish them, because they didn't know what they were agreeing to, and I didn't know they agreed to it. Does that make sense?
Yeah, so just to be clear, the reason why the Court of Criminal Appeals is referenced here is because the Court of Criminal Appeals controls the funding for all of the judicial training entities that train on every type of case. So the goal here was the Court of Criminal Appeals has the leverage to get the training entities to deliver the training. And so, for instance, whether that's family, civil, juvenile, criminal, whatever, the intent would be that the training cover this in all instances, so that even family court judges, very importantly, family court judges would be able to get this training as well. So that's the reason, specific reason why we referenced them. There was going to be originally the draft this had just saying the training entities would do it, but the thought was by referencing the Court of Criminal Appeals, it provides the leverage because they control all the dollars.
And that generally goes through the Justice Center, right?
That's correct. It'd be Texas Center for the Judiciary, the Texas Municipal Court Education Center, Texas Justice Court Training Center, as well as the prosecution and defense associations, because they may also need to be trained because they want to include some of this information in their materials. But we need to work with the family law section. I see Steve resident here. So we'll do our best to get this word out as far in line as we can so that everyone knows what we're doing.
So it's a committee motion, does not require a second, and quite a bit of discussion. Any other discussion on the motion to finally adopt the...
I move to adopt the rule with the amendments that David has.
All right. Any other discussion? All in favor?
Aye.
Opposed?
Aye.
Passes. Thank you.
David, this is Sharon Keller, would you please show me abstaining?
Abstention.
Oh, abstention. Yep. Yes, we will.
Thank you.
And just to verify, make sure I'm clear, we're clear in the minutes, that would be effective September 1st of 2020, and we would publish it for final adoption in the register as part of the motion.
Okay. Well, we appreciate Judge Moore's work on all this. Kelly is leaving the bench to become director of the Lubbock Private Defender Office. She called me the other day. And their gain is our terrible loss, because Judge Moore's just been so helpful on all these issues for so many years. But the public defender's getting a real champion out there, so that's great.
Thank you very much for your kind words, Chief.
Bet. Anything else on those issues, David? Then we'll go to the Data Committee report. Judge Gravel.
Good morning, Chief. Happy Valentine's Day. As a reminder to all who need that. The Data Committee met a couple of days ago, and perhaps that was more rhetorical than anything. The Data Committee met a couple of days ago and had about a 2-hour meeting, really trying to figure out how do we tackle the new guidelines from the council on collecting case level data. And just as a reminder to the new members of the council, it was the recommendation of the Judicial Council, I believe, in 2018, that we begin to collect case level data. And we're very grateful. The legislature helped us with some funding to create the case management system for counties of populations of less than 20,000. And it's my understanding that that is in process with OCA, and that perhaps sometime soon, I guess the RFPs are out. Would that be the right?
It will be coming out soon.
Be coming out soon, and so that will be a wonderful tool. Thank you for the money to actually help us solve problems from the legislature. We're always grateful for that. The committee received an update from Paul from the National Center of State Courts, who shared with us the new National Open Court data standards known as NODS. And national standards have been set, and hopefully in the days ahead, there will be an adoption of all of those national standards here in Texas. They're leading the way. And then Angela from OCA, our Chief Data Officer, we began an overview of all the current data that's being collected by OCA and their definitions, and really trying to understand the concept and the structure of how our data is collected and what we were trying to accomplish. The committee decided to begin analyzing the data first on the criminal side, the criminal data set, and the Judicial Council and our committee will work with reporting counties. OCA is going to consult with stakeholders involved in conjunction with data collection, as well as our committee to determine what's really essential for the collection. Chief, I'd like to use the analogy of the old African proverb of how do you eat an elephant? And really it is one bite at a time. And as a committee, we have a large project to work on in the days ahead with how we collect data. And I think we started at a good place, working on the criminal side first. And our hope is to have recommendations back to the council. In fact, I'm commitment that we're going to have recommendations back here on the criminal side at least for our June meeting. And Chief, we do have one ask from you specifically. One concern that we have with all of the new data that will be collected and brought on at OCA is how Rule 12 really affects that at the state level. And so we feel like that probably needs to be revisited before we begin collecting all of the data as to, what's the right word, Mr. Slayton, to protect everyone involved and to assure that we're handling it in the right way. Our data committee's working hard, and we will have recommendations back in June on the civil side. Was there anything I missed, Mr. Slayton?
No, I would just note that Mr. Young volunteered to lead that project at SCAD.
Participate. What is the status of the case management rollout?
So the case management system, as was noted, Legislature provided $30 million to allow us to procure a system and some ongoing funding to support it. As you probably know, many of our smaller counties don't have the resources to really have sophisticated case management systems, and so this will provide an opportunity. We have the project kicked off. We've got a project manager assigned to it. We are in the process of beginning to gather requirements. We've put together a pretty broad stakeholder group of individuals all across the state that can help us talk about what the requirements of the system need to be. And we've engaged with Gartner. Many of you may be familiar with Gartner, their technology provider, to assist us in getting the procurement ready. So the intent is to put that procurement out on the street later this year and to hopefully have a signed contract and begin to implement in some of the counties by year's end. So pretty ambitious timeline, but we're working hard to try to get it up and operational as quickly as we can.
Questions? Yes.
Chief, what are the goals of improving the e-filing system, just in general? You don't have to go into great detail, but we get a lot of questions.
It's a good question, and it's pretty close in line with what the Chief was talking about with timelines and things. So the electronic filing system, as you all know, has been around since 2014. That is a contract which expires August 31st of 2021. In the next few weeks, I'm not going to give you an exact date because we're not really sure exactly the date, but the next few weeks OCO will be releasing an RFP for a new e-filing system. We, as part of that process, engaged with a broad group of stakeholders. We had about 85 subject matter experts who assisted us in determining what is essential from the current system to maintain, what are improvements that need to be made, what are wishes on the wish list. And so when the RFP goes out, it will have the requirements that must be in place on day one, which is basically we've got to keep the system up and operational and allow people to do what they need to do, as well as these are required to be implemented to make improvements, and then lastly the wish list of things that we would like for them to do as well. So the subject matter experts were able to bring some of the things that you mentioned to the table and ask for those improvements to be made. And so the intention is that contract will be signed in the fall, and the successful vendor will be responsible for implementing that starting in the fall of 2021.
This is the e-filing, e-access, and now the case management, and the data collection, and analysis is all an enormous project that we're moving on. I don't know if we're ahead of all the other states, but we're certainly in the first two or three, and maybe ahead of everybody else that's trying to do this. A lot of smaller states could do it a whole lot more easily and aren't even trying. So it's going to be very helpful for us.
Chief, I would just like to say thank you to Senator Zaffarini, and I know that you, Representative, are new with us. We're grateful that you're here. But this legislative decision is going to, I think, impact somewhere close to 150 counties in Texas. And so on behalf of the small counties, I just want to say thank you for caring. And it will have significant impact on Texas. So welcome. And thank you again for y'all's hard and heavy lifting for rural Texas.
It's nice to hear. We hear a lot of pleases, but very few thank yous.
We won't promise not to go back with pleases. We'll thank when we can.
Well, we're glad to have Representative Smith with us, and graduate of Austin College, as you might expect, since he represents that area up there, and South Texas College of Law, and thank you. Glad to have you.
Well, thank you for having me, Chief, and I fill some big shoes.
Yep.
In a lot of ways, I know Andy was a very valuable member. He's been tremendously helpful to me in the transition here. He spent quite a bit of time on the phone with me, explaining kind of the lay of the land. So thank you for the warm welcome. Very much.
Very welcome. Then we'll go to Public Trust and Confidence. Judge Blank.
Thank you, Chief. The Public Trust and Confidence Committee met January 23rd for about 2 hours. We had a number of subjects on the agenda. We first heard from Judge Ruben Reyes about the family treatment courts and the recommended quote-unquote best standards. There are a number of these hybrid courts. The Judicial Council previously adopted best standards for adult drug courts back in 2016. So now the committee agreed unanimously that that recommended standards with a 2-year delayed implementation should be sent to the Judicial Council for approval. Family treatment courts have a set structure to meet the needs of the children, parents, and families affected by substance use disorders that come to the attention of the child welfare system. So, well, I don't know if David, is this the time to provide that motion that we have on the agenda? We would move for approval of family drug court program best practice standards, and we had added to that a 2-year implementation. Judge Reyes agreed with that. That would be very helpful.
All right, committee motion does not require second discussion. Then all in favor of adopting those best practice standards, aye.
Aye.
Opposed?
Aye.
Thank you, Judge. Anything else?
Yes, we heard from Jesse Rutledge from the National Center for State Courts on the State of the State Courts 2019 poll. The poll this year was conducted online versus by phone call. Evidently, people aren't answering their phones. So the numbers were similar to prior years, but some numbers were down, specifically with confidence in local police, which was down 12%, and confidence with state courts down 11%. The numbers on procedural fairness are still high. One thing that was very clear and led to a lot of discussion with the committee was that those under 40 particularly want to interact online with our courts and our websites. This led to discussion of our committee on court websites and perhaps minimum standards. This may also be part of the Centers of Excellence. The municipal courts right now, and we have about, I guess, 96% pro se defendants, we're looking at this as well, and we've seen that many judges aren't even aware, they haven't even looked at their websites, but definitely the public are looking at that for information, and this is an area that I think courts need to address. So then we heard from OCA's Public Engagement Pilot Project. I know the chief has mentioned the summit that they had, was it 2 years ago, 2 or 3 years? It's a little while now in Dallas.
2.5 years.
Yeah, that sparked a lot of the work of this committee and this specific public engagement pilot project. At the time of our meeting a couple weeks ago, the project had roundtables at a small city, Alpine, and a mid-sized city, Brownsville. The idea is to examine the public's perception of our courts and how we're responding to the community's needs. There's a roundtable planned in Houston next week. Then we also discussed civic education ideas, legislation requiring courts to text, email individuals with court date information. Again, everyone, the most common thing that's connected to people are their phones. And around the country, a lot of courts have worked with texting with success, especially with failure to appears. And ideas to get more media attention to our courts, as I mentioned. One of the committee's recommendations from 2018 was to increase civic engagement opportunities such as mock trials. And Senator Zaffarani, who's a member of the committee, has a brief update for the council on the mock trial work.
Yes, thank you, Judge. And Judge Gravel asked for an update last time. You have before you, you've been wondering perhaps why you have this imprinted bag in front of you. This is the bag that every student who attends a mock trial receives. And in it, that student receives these pencils. Either a Texas pencil or a heart-shaped pencil. From me, it's called a pencil because it's bent into shape with my name, and the judge's gavel pencil. So these are parts of the treats that the students receive. They also always receive a treat that is appropriate. This is called a Wickety Witch Pop, and you may have a different one. And as every student arrives, he or she receives a lanyard to keep, and it's interesting that they've all been asking if they need to return them. But they keep a lanyard with a badge. And you'll see that the lanyard has the name of our program, Access to Justice Class in the Courtroom. And everyone upon entry receives this badge that says Member of the Court of Public Opinion. But then some of them trade if their names are drawn to serve on the jury or as a deputy officer. And then they give this back and get the appropriate badge. But what they also receive is what you have in this folder, the Senate folder. You don't need to open it. I will tell you what's in it if you want. But basically, they receive a program. And notice how nicely it's designed. The design, of course, was contributed to us with the names of the cast and the steps in the trial and the names of our sponsors. They receive this handbook that also diagrams for them, or rather describes the courtroom itself, the steps in a trial, and handy-dandy vocabulary. At the very end, so that they won't find it at the beginning, is a summary of the particular mock trial. But we asked them to keep this for future reference. And there's some law students who have asked for copies, by the way. It has things like the grounds for an objection, etc. They receive this. Then afterward, from their teacher, they receive a certificate of achievement. This is a mock trial student scholar certificate signed by the judge, and the members of the cast receive a mock trial scholar certificate of appreciation designating the number of community hours that that cast member will receive. You also see some clips of the kinds of coverage that we have received, and we have received all kinds of coverage. The Laredo Times has been incredible. You can see color pictures. Look at this. This is Pancho Claus versus Cruelia versus Pancho Claus. And there's a magazine named Imágenes that I have here, and every month they provide us 4 pages of coverage. Look at that. Color photos, and including a photo of every single class that comes to the mock trial. And they name each school, and they have a summary of the trial itself. But basically, this is a program that we started in December of 2017, and it has been successful beyond our expectations. What you have in your packet includes, first and foremost, this handout that lists for you all the materials that you are receiving, and then it has a report that is prepared for you. It's a 9-page report, mind you, but don't worry, I won't read it for you. But this is something that you can hand off to someone, a judge who's interested, for example, and say, this is how it's done. And that judge would read this, perhaps need a little extra help, but we can help walk that judge through it. You also have, for that purpose, an entire script. This is a 38-page script that we provide for all the members of the cast. It has all the directions, the names of the characters, even tips on how to act. For example, we instruct all the participants to be likable, even if they're villains, to be likable, so that the students will like them, not hate them. And you'll notice if you ever look at it that it's in English with a lot of Spanish. And it's because we're in Laredo and most of the students are bilingual, and so we do that appropriately. You also have a copy of the materials that we give the teachers, because we want the students to come in prepared. So we have materials for the teachers that are called teacher tips. Then we have the standard vocabulary that we believe the students should know before coming, and it's a 1-pager, things like defendant, guilty, not guilty, objection, etc. And then we have a student participation form, so that we know exactly what students to expect and how many are coming. And then we have a template for my welcome, because I welcome the students. Today I'm not, there's a mock trial going on today, so the judge is playing my role for me. But I always welcome the students and tell them what to expect, explain what they're there, what they will see, etc. But after we started in 2017, we used an ABA script for Goldilocks, and we used a framework from Judge Prado, who was then a United States appellate judge and is now ambassador to Argentina. And then we decided we can do better. That's when we decided to write our own. And we write our own targeted for a specific grade level, a specific age. And every single mock trial is intended to not only introduce the students to the system of justice, how a trial is conducted, the consequences of disobeying the law, because they deal with punishments and all of that, the ability to serve on the jury in the future, and every single mock trial is tied into a social justice lesson. For example, the Three Bears versus Huerita Locks, as we call her, focuses on discrimination. You know, those lying bears think that, oh, that's the Three Little Pigs. The Three Little Pigs think that the big bad wolf, as we call him, and we call him Billy Bob Wolf, that all wolves look alike. They all look alike, they're all big and bad, no matter how small or how good they are. So they're dealt with in terms of discrimination. Everyone has a social justice lesson. Sleeping Beauty becomes Snoring Beauty. Snow White becomes Snow Green, an environmentalist. BB Wolf becomes Billy Bob Wolf. And all of these changes are intended to demonstrate to the students that when you come into the courtroom, everything you know and everything you think should be left outside the courtroom. And that they should make decisions based on what they see, what they hear, and what they believe. So basically, those social justice lessons are interwoven into the script, along with a lot of jokes, a lot of anecdotes, a lot of biculturalisms that are always translated. For example, one character will say, "Ay te guacho cucaracho." And then some other character will say, "That's like saying, see you later, alligator." So it's not translated literally, but figuratively. And there's even singing. Some of our volunteers who participate sing. So they'll sing, that in one case the attorney gets into an argument with a witness and they sing from Annie, Get Your Gun. Anything you can do, I can do better. And they go back and forth, and it's just unbelievable how effective that is for the students. But the students enjoy it, and they learn, because what we explain to them is that this is an educational experience, but also entertaining. And there is great competition to come to the courtroom now. The first time we had a mock trial, we had 25 students. Now we typically have 160. And we have now presented 43 mock trials based on 15 original scripts, plus the canned ones that we used, but 15 original scripts, and have now reached more than 6,000 students. And the impact on the students and the parents has been tremendous. When the students first came, they were terrified. There was one class that was brought in with no preparation. The teachers brought them at the last minute. They thought they were going to be arrested. They thought they were going to jail. There was a little girl who was near tears. All of them terrified, and then they realized why they were there. So now the students are really eager to come because the word has gotten around. And you can imagine dealing with 6,000 students. We've dealt with 3 independent school districts, and we've dealt with students from 3rd grade through university level. So every mock trial is developed at an age-appropriate level. Every one is intended to introduce students to the system of justice, but also to be entertaining. And we have had so much fun. None of this costs the county anything, or the court anything. We have sponsors for everything. For example, Ken, your sister, Sandy, paid for those bags. $9,000, by the way. And yet she paid for them for a year's supply. The treats are provided by someone else. A law firm provides all the printing. This costs the judge and the county nothing. And all payments are made directly to the vendor so that we don't exchange money. But it's just a wonderful opportunity to educate the students. Interestingly, many parents and teachers have reached out to us, and they have told us things like, my daughter had never talked about going to college. Now she wants to be a judge. Imagine. And so they have changed in many ways. They want to be judges, they want to be attorneys, they want to be bailiffs, they want to be jurors. And now the teachers are saying, I used to do anything to get out of jury duty, now I'm looking forward to it. Now I understand. So we've had a terrific impact on these students, and it's just a wonderful program that I really wish that we got more judges involved in participating in. Now, OCA has been posting some of the materials, some of the scripts, because After we produce them bilingually, we go back and take out most of the Spanish, not all. Sometimes it's impossible. For example, today they are hearing the case of J.G. Giant versus Yak in the frijol stock, instead of Jack in the beanstalk. It's Yak in the frijol stock. We can't take the Spanish out of that. You lose the joke completely. But we're trying to make it accessible. Everything is accessible free. So if you, any judge here, or if any other member wanted to get a judge involved, you could give them the script, we could give them other scripts, and they can use anything we have as a template, including the certificate design, the bag, or go as deeply as they want to into it. The students, the participants have wonderful costumes, as you can see from the pictures. They're just wonderful, and they all look wonderful. On page 2 of the report, you have the list of the subjects that we have so far. And they include Alejandro versus the Beast, also known as the Prince, Lex Luthor versus Soup or Man, Cruel Elia versus Pancho Claus, Queenie versus Snow Green, and the newest one is the Wizard of Ooze versus Dorothy, because she's a dork. So that's going to be very cute. And the next one that I intend to write is Prince Harmony. Rhymes with charming. We are going to charge him with bigamy because he was married to Snoring Beauty, Snow Green, and Cinderita at the same time. If you think about it, that's what the fairy tales establish. It's all Prince Charming. So we will charge him with bigamy. And he's in for it. The sponsors that we have been wonderful, and it's gone to the point that people contact us and say, what can we do? For example, Sandy, what could she do? She said, I'll pay for all the candy, because the students get the treat, and the reason for the treat is simple. We use this as part of a lesson that bribery is wrong. So in every single trial, somebody either offers the judge or the jury candy or says they brought it for the student. But it's always used as a lesson that bribery is against the law and that there are repercussions for trying to bribe anybody. So we've done that, and we've reached out to people and accepted every sponsor who offers to help. We find something for them to pay for. And that's how we add treats for everybody. And the bag is a perfect example so that they have it and they take it home. There is one sponsor who now live streams the mock trial for us. Every mock trial is presented twice, and the second one is always better than the first. So the second one is live streamed on my website. You can go to it and find it. It's just Judith Saffirini. And interestingly, many teachers are live streaming it to their classes. So some of the mock trials have already been viewed by more than 1,000 people, and some of those people have shared it with their classes. So the impact has been wonderful, and we have really enjoyed it. I hope that some of you will try it or ask a judge to participate in the program. I would recommend it highly. Thank you, Judge.
I'll just point that all the materials, if you want to go look, are posted at our website, classinthecourtroom.txcourts.gov. So.
It's an amazing response to the lack of teaching of civics in school now, and I think that's going to make a big difference across the state. Thank you, Senator.
Several efforts directed aimed in that direction. So, anything else, Judge?
That's it.
Well, it would be a good program, Senator, if only it were better organized. So. I need you to get you to come work for me. Then Strategic Vision Committee. This is the only committee that's already gotten press. Making us all report in the Texas lawyers. Justice Force.
Thank you, Chief Justice Heck. The Strategic Vision Committee met yesterday and focused its discussions around 2 steps towards the development of a strategic plan for 5-year strategic plan addressing the goals and needs of the Texas judiciary and court system. The steps that we discussed are step 1, identifying the stakeholders, of whom there are many. This is obviously not just a court or a judge-directed or driven undertaking. This is an undertaking addressing all people who have interaction with the courts. And so we've discussed specific strategies for outreach to the many stakeholders to get input about the goals, vision, and mission that this committee will articulate. The second step is to begin work on articulating the mission, vision, goals, and timeline. To borrow Senator Zaffarini's structure, she too has contributed to the organization of this committee's activities in a very, very helpful, profound way. And so I think it's safe to say that we're looking at a double track process to identify and obtain input from the stakeholders while also beginning the process of developing the mission, the vision, and specific goals. Towards this second step, we have begun to examine examples from other states and other court systems, including a program and a statement that the Arizona courts have assembled. That's been one example that we've started looking at and started drilling down on. Another is the Statement of Core Values by the federal judiciary. So we will be looking at those and other sources to begin building out this project in these steps to bring a result to this body for its consideration.
Great. Questions? Wonderful. That's good. So the plan for the new members is to let the committees finish their work. We'll have concrete recommendations in June, which we'll be looking to adopt, and then we'll begin drafting legislation where we need it, or rules where we need them, for approval in the fall. On the legislation, it's important to get an early start and pre-file as many bills as we can. This is not, again, this is not just wishful thinking, but usually the council recommendations are given quite a bit of weight by the legislature. So where we need help, that's what we'll do. And when we think we can do this on our own and should, then we'll be doing that too. So that's kind of the plan. Great. Well, the new business is to recognize Meredith, who's retiring, and this, what you have in front of you, all this organization and work that's being done, it doesn't just magically happen. It's not just that we wake up in the morning on the same page. We need coordination and help. Meredith has provided that at OCA for a long time, and she served her very faithfully, and so we wish her the best. We have a little presentation to make, I think. Senator Zachary. Yes.
Did you want me to read it? Mm-hmm. This is Senate Proclamation number 125. Whereas the Senate of the State of Texas is pleased to recognize Meredith Higgins, who is retiring from her position as an executive assistant at the Office of Court Administration after a long career of service to the state of Texas. And whereas Meredith Higgins began working for the state in 1992 as the clerk in the Parole Division of the Texas Department of Criminal Justice, she went on to serve the department as an administrative assistant with the Texas Board of Criminal Justice and the Community Justice Assistant Division. In 2005, she transferred to the Texas Judicial Branch and began working at the Office of Court Administration. Whereas in her time with the agency, she has excelled in a broad range of duties. Her responsibilities have included developing agendas, drafting policy, conducting research, and maintaining complex databases. She has overseen scheduling and records management, and she has been a trusted point of contact for executive management, board members, legislators, members of the judiciary, and public citizens. And whereas talented and resourceful, Meredith Higgins has handled the demands of her position with exceptional efficiency and dedication. She is respected and admired by her colleagues at the Office of Court Administration, and her presence at the agency will be greatly missed. Now therefore be it proclaimed that the Senate of the State of Texas hereby commend Meredith Higgins on her distinguished career and on her service to the state, and extend her best wishes in all future endeavors, and be it further proclaimed that a copy of this proclamation be prepared for her as an expression of esteem from the Texas Senate. And this is...
While the photos are being taken, I would like to thank our House members too. Before Representative Smith was on board, Representative Murray and Representative Leach assisted us in getting a resolution from the House that we gave to Meredith at her retirement party. So this is her second proclamation / resolution, so thank you.
And she has always admired my handkerchiefs, which I use to clean my glasses, so we have her own 2 handkerchiefs.
Well, I don't want to ruin the chief's brilliant streak of ending his meetings on time, so I just want to say thank you to everyone. It's been an honor and my privilege to serve the judiciary in the state of Texas. And David's late. Thank you.
All right, is there any other new business? Good of the order. Our next meeting is June 12th. And if there's nothing else, we'll stand adjourned.
Oh,